a practicing lawyer in the Madurai bench of the Madras High Court, to welcome all the participants. Over to Sister Amala. Please unmute your mic. Please unmute your mic. Yeah, thank you, sir.
Warm good evening to one and all present virtually. Creativity leads to thinking, thinking leads to knowledge, and knowledge makes one great. This webinar is one of the forum to update our knowledge in becoming great. It gives me immense pleasure to welcome the participants of the webinar, both Reverend Fathers, Reverend Sisters and Brothers who are working in our institutions and who are administering the education institutions, and the media, both national and regional. I would like to take this opportunity to extend a warm welcome to the star of the show, our distinguished key speaker, Mr. Isaac MOHANLAL, Senior Counsel, Madras High Court. A warm welcome to you, dear sir. A recent judgment of Honorable Apex Court on 1st of September on the issue of teacher eligibility test made a great chaos and confusion, not only among the teachers and management, it is among the education department itself. Whether the teacher eligibility test would be applicable to, because all these days or years, the department was having an understanding that teacher eligibility test is not applicable to the minority. Now, this judgment has even created a confusion among the department, even whether to approve the appointment for the teachers working in minority educational institutions. Not only Supreme Court has made such a chaos, even recently, after the Supreme Court judgment on 1st of September, we would be aware of that. On September 10th, the first division bench of this Madurai bench, headed by Her Lordship Anitha Sumant and Kumarappan, has held that because as many of you would have been aware that in Madurai bench, Her Lordship Justice Nisha Banu and Justice Srimati had held that TET would be applicable to irrespective of institution, whether it is a minority or non-minority. That what happened, we had filed a review that has been referred to the third bench. While the reference is before the third bench, can a single judge allow the writ petition filed by the institution having that TET is not applicable to minority? That was an argument was placed before a single judge on 9th, and 10th the division bench says that until the reference is answered by the third bench, you can also follow the Paramati judgment, which says that it is not applicable. So on 10th of September, a division bench of Madurai bench says that TET is not applicable to minority education institution. What happens 11th? The same argument is placed before the single judge. The single judge does not accept. He says that I will only order, saying that give approval from the date of appointment and only disperse the salary from the date of the order. So that again creates a confusion. It's not only among the teachers, because even among advocates also, we do not know what the position of a teacher eligibility test for minority, especially because it's a uniform factor that TET is applicable to non-minority with a cutoff date. But what about to the minority, whether it is applicable or not applicable? And even more confusion has been created by the Honorable Apex Court, whether TET is minority, TET is applicable to minority or non-minority, whether TET is applicable to for the promotion, whether do we need TET for a promotion? And thirdly, there is a confusion that whether without TET can we continue in a service? And fourthly, they say that if you do not have a TET, you should quit the post after 2 years. If you are not going to clear it, get your all benefits and get away. So all this confusion has created those judgment, whether it is applicable to minority or those judgments only is applicable to government schools. That is also in confusion, because there is the reference also has been made with regard to minority to Chief Justice. So with these all confusions, I know that all the participants are here. because on September itself we got lot of phone calls from the teachers, because they are very anxious about it, whether we need to, those who are in service, can we continue our service, or do we need to clear TET to continue in our service, or do we need to clear TET to for the promotion. So all these confusions the courts have created currently, because for some extent it was settled, and even the department comes out with a proceeding saying that with a letter, in minority education institution who have been appointed prior to 31/1/2023, as everyone would be aware that 31/1/23 is the date where the new act, that is Private Schools Regulation Act 2018 and Rule 2023 was introduced and came into force. So prior to that, who have been appointed in minority institutions, you can make an approval. That is the stand of the state government. Now having that stand, but the state government itself keeps on preferring appeal before the division bench, saying that it is applicable. So the government themselves are not even clear about it, whether they have to make it applicability of TET to the minority or non-minority. Even to that extent, even government advocates themselves, they are not able to place the correct facts before the court. So this is the confusion among the teachers, among the departments, even among the advocates. So it would be the right time that it is timely and with the right speaker. This webinar has been organized jointly by JCERT and laws. Surely through this webinar, all would be enlightened and enriched and clarified with the wisdom of our speaker. Thanking every one of you, welcoming everyone to this webinar. I am so happy that everyone would be profited and everyone will have a good sleep, I think, today. So thank you, Father, for giving me this opportunity. And over to you, Father. Thank you, Father.
Thank you, Sister Amala, in putting us in the proper perspective. Proper perspective. You being a lawyer, very good, extremely good. You are able to place the confusion in clarity. Confusion in clarity. Thank you, Amala, for welcoming all of us. Now, over to Father Sandanam to introduce the speaker in brief. Over to Father Sandanam. Unmute, 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 unmute. Unmute. Okay.
Father Kennedy has told me to be brief, but I need to be very elaborate. This is the time, okay, our resource person has joined, okay, on time, freeing all the other works and then giving importance to this webinar, because it is an important one, okay, for all of us, institution, teachers, and the management. So I just first of all say good evening to one and all. Indeed, I am delighted to welcome and truly honored to introduce Mr. Isaac MOHANLAL, Senior Counsel, Madras High Court. Mr. Isaac MOHANLAL is an icon and a leading legal luminary of minority rights. He is a voracious reader, versatile speaker, visionary leader. He likes greatly most of the writings of Lord Denning, the King's Counsel, and highly regarded as people's lawyer and jury of England, and similarly, he loves immensely the writings of Lord Byron, the romantic poet of England. He is specialized in constitutional, civil, and criminal law practice. He has mastered in minority rights. He feels his mastery for the advancement of the institutions of the minority educational agencies, because he believes that it is because of the educational institutions of the church. The education is democratized in the caste-ridden Indian society. Mr. Isaac MOHANLAL's approach, understanding, and commentary over the constitutional rights and fundamental rights, especially minority rights, is spellbounding. I have seen people enter his chamber in utter gloom, and after a few minutes of discussion with him, returning face bloom. He is a hope giver. He has appeared for all the Jesuit colleges and schools in Tamil Nadu, and he is their standing counsel. He has been part of and played an outstanding role in making the corporate policy of higher education of Jesuits in Tamil Nadu. He is also representing the Sacred Heart College Tirupattur of Salesians, Stella Mary's College, Madras Christian College, Women Christian College, Holy Cross College, St. Mary's College, American College, Lady Doe College, Fatima College, Nirmala College, Sarah Tucker College, Tyagaraja Engineering College, RBS Engineering College, St. Francis Xavier Engineering College, Sri Mookambika Medical College, Kulashekaram. Like that, he has a big list of being their counsel. He has also appeared for Madurai Kamaraj University, Manonmaniyam Sundaranar University, Tirunelveli, Periyar University, Salem, and Tamil University, Tanjavur, Indian Institute of Technology, Chennai, and the Airport Authority of India. He is also appearing in various other high courts such as Delhi, Karnataka, and Kerala. He is also arguing cases in the Supreme Court of India regularly. He is the founder president of the Madurai bench of Madras High Court Bar Association. He is the general secretary of Madurai Law Academy since 2010. He is also an invited resource person for Judicial Academy that trains judicial officers in various states of all over India. He is a much wanted advocate to be elevated as the High Court judge. Former Chief Justices of Madras High Court like Justice Markandeya Kachu, Justice A.P. Shah, Justice Ganguly, Justice Iqbal, Justice S.K. Kaul, and Justice Indira Banerjee pressurized him successively, but all persuasions ended unsuccessfully. Mr. Isaac Mohanlal has gently declined it. It is a loss for him, but a gain for us. We have a lawyer, Mr. Isaac Mohanlal, who can stoutly argue for our cases. It has been my experience and other church people, when we visit his office, he never makes us wait. Once one can right royally enter his office and chamber. His opinions and guidance are not just for tackling that moment's crisis, but setting things right with foresightedness. We are indeed indebted to him for sharing his treasured time and legal intelligence in shaping the rights of minorities in the Indian Constitution through court arguments. I once again welcome on behalf of JCRT and Lars and all the people who have joined here, Mr. Isaac Mohanlal, our senior counsel, and thank him for being a part of this webinar and consenting to enlighten us on the recent judgment of the Supreme Court on TET. Welcome, dear sir. And
Thank you.
a note of appreciation and wishes of happy birthday to Father John Kennedy, celebrating his birthday today.
Thank you. Thank you, Sandanam.
Yeah.
Thank you, Sandanam. Thank you for the for elaborate and impressive introduction to Mr. Isaac Mohanlal. Now before the keynote speaker speaks, Isaac sir, there are 387 people attending through Zoom. There are 70 people watching through YouTube. A request to those who are watching through YouTube, please, if you have questions, type them in the chat box in the YouTube. I will take them. I am watching both of them. I can take them up and then give to Mr. Isaac Mohanlal. Let me not waste much time. Now, the mic is handed over to the eminent speaker of the day, Mr. Isaac Mohanlal. Please enlighten us from all the confusions and make us peacefully sleep tonight. It's all over. It's all left to you and over to you, Mr. Isaac Mohanlal. Thank you.
Good evening, fathers, sisters, and ladies and gentlemen. So
just a note, there are also non-minority school administrators participating. Just keep that also in mind. Yeah, thank you.
Very well.
Thank you.
So nice to see some of you online. Your faces are almost 5 or 6 people are available on the screen. Anyhow, I'm told that Father Kennedy is celebrating his birthday today. And probably there is a reason why you are keeping yourself away. instead of coming over here and sharing the cake with us.
Okay, thank you.
But anyway,
Thank you.
birthday is for you. But we will wait for the day when you will bring the cake.
Thank you. Thank you.
Father
Thank you, sir.
Sandhanam, thank you so much, Father Sandhanam, for the high-sounding adjectives with which you gave the introduction. And I doubt whether I deserve all these things or not. Huh? Sister Amala gave a very beautiful introduction, and she said that enough and more confusion is being created by the law as well as by the courts. Certainly, some kind of confusion prevails. But anyhow, we are here to thrash out all those confusion. And if you ask me straight the question, whether TET is needed for minority institutions, as on today, I would say it is not needed. The whole of the minority institutions are exempted from the rigor of this TET as of now. And more so because of the judgment delivered on the 1st of September, which makes it clear that the minority institutions are for the time being exempted from having this requirement of TET. So, as Father Kennedy told that even non-minority representatives are also participating here, let us have a brief idea about the evolution of the TET.
Okay.
How it got involved, because everywhere you know that previously the state governments were actually in control of school education. Therefore, state government laws were actually applicable for these school education departments, and qualifications had been prescribed by the states. This TET is a new introduction at the national level, which happened because of the Right to Education Act, what you call RTA Act 2009. And this 2009 Act also has got a reason behind, a history behind it. If you remember, that was sometime in 1991. Supreme Court for the first time held that elementary education is a fundamental right. 1991. And Supreme Court said because there is an article number 45, which mandated that within a period of 10 years, the state shall endeavor to provide free and compulsory education throughout the country for children from 6 to 14 years of age. Sometime in 1991, when the Supreme Court witnessed that several decades had passed on and the right not being given to the children, Supreme Court declared that this is a high time that we shall declare this as a fundamental right, which is traceable under Article 21, that is the right to life. Supreme Court said that the right to life means right to have a meaningful life. Meaningful life would be possible only with education. Thereby, Supreme Court in 1991 declared that this is no longer a directive principles of state policy, but it has ripened into a fundamental right. That was tested again in the next year, 1992, in the famous Undi Christian's case, where the Supreme Court said what is said in 1992 is right. Thereafter, 10 years later, in 2002, the famous judgment of, most of you might know, the TMA Pai Foundation case in 2002, where 11 judges of the Supreme Court sat and decided. They also affirmed that this universal elementary education is a fundamental right for children between 6 and 14. In that year, the Parliament incorporated a new article in the Fundamental Rights chapter, Article 21, capital A. That was by way of the 86th Amendment to the Constitution, saying that the right to education, free and compulsory education for children between 6 to 14, the state shall provide by way of laws to be made by the Parliament or by the state legislatures. This 2002 promulgation of this right as a fundamental right, what it exactly says, the state shall provide free and compulsory education to all children of the age of 6 to 14 years in such manner as the state may by law determine. Therefore, in 2002, this article was introduced, but nothing happened for 7 long years. The article says it shall be implemented through laws that are to be made. So 7 years later, that is in 2009, for the first time, the Right to Education Act 2009 was legislated and put into operation. That is the law through which the right is to be enforced. And this law gave rise to several arguments, especially by the minorities. Mainly 2 or 3 factors. One is Section 12, the other is Section 23. Section 12 said every institution that is recognized shall accommodate at least 25% of its admission capacity by providing those seats to the neighborhood children who are socially backward. That is the disadvantaged group. They should be given 25% seats at least in each and every institution that is recognized. That is Section 12. Then Section 23 says that because this education at the elementary level is going to be made a fundamental right, the education should be of good quality. Quality education would be possible only when qualified teachers are appointed. Therefore, there should be a basic eligibility criteria for those teachers who are to teach at the elementary level. That eligibility criterion is what we call the TET, Teachers Eligibility Test. These provisions actually, especially this is our first provision, Section 12, which mandated all recognized institutions. There is no distinction between minority and non-minority. Law said all institutions shall accommodate 25% of the admission capacity to the neighborhood children. So that created much furore. The law itself was put into challenge before the Supreme Court. Supreme Court in the 2014 judgment, what we call the Paramati case, what Sister Amala was referring to. The Paramati case, the Supreme Court said the whole of the law, that is 2009 Right to Education Act, will not apply to minority institutions. The basic reason why the Supreme Court said so was, if you are compelling a minority institution to admit students of particular type against their wishes, it would be an encroachment into the fundamental right of the minorities. Now, the issue before the Supreme Court was actually a very dichotomic issue. One is children's right under Article 21, capital A, fundamental right of elementary education, vis-a-vis the minority educational institutions' fundamental right under Article 30. And Supreme Court found how to compromise the two. Supreme Court found that this compulsion on the minority educational institutions to compulsorily admit 25% from the neighborhood children was a real encroachment, infringement of the fundamental right that is given to the minorities under Article 30, because one of the essential facets of the right of administration is right to admit students. By way of this compulsion of 25% admission, they are actually infringing upon the fundamental right of admission. That is why how the Supreme Court declared the Right to Education Act will not apply to minority educational institutions. That is the 2014 judgment. But incidentally, Supreme Court did not go into the other aspect, TET, whether TET would apply to minority institutions or not was never considered in the 2014 judgment. Then much arguments happened later throughout the country that once the Right to Education Act itself is declared as not applicable for minorities, how can one wing of that or one segment of the law, that is a TET, can be applied on minority institutions? So everybody started arguing TET is after all a byproduct of the Right to Education Act. When the act itself, the law itself is not applicable, it is the wholesome. How can a limb of that law, that is TET, can be applied on minority institutions? Thereby, everybody started arguing it won't apply because the whole of the law is not applicable. And the courts started taking the view first, it won't apply to minority institutions because this is a byproduct of the 2009 Act. Later, some of the courts like Bombay and in Madras also, some of the judges took the view, though Right to Education Act was declared as not applicable for minorities, it was only with reference to Section 12, namely admission of neighborhood children. This TET was never considered. TET was not independently decided by the Supreme Court. It is, after all, a qualification. Therefore, as long as it remains as a qualification, minorities cannot say, we will not have qualified teachers. Therefore, some of the courts took the view that TET as such would apply. Only the compulsion of admission of 25% only will not apply. This is how the conflict arose. Thereby, the matter came up before the present bench of the Supreme Court, which rendered the judgment on the 1st of September. Because of that, we are all here today. Now, the position regarding minorities, please remember, this is a two judges bench. Paramati was delivered by a bench of 5 judges. Therefore, in the legal practice, legal parlance, what we say is that benches of smaller strength are bound by benches of larger strength. Paramati was by 5 judges. The present judgment on 1st of September is by 2 judges. The question before these 2 judges bench in 2025 is whether TET is an eligibility or a qualification. Suppose it is a qualification, the argument was, suppose it is a qualification, minorities cannot say no. At the same time, if it is an eligibility, the minorities can be heard to say no. But Supreme Court now, considering these two expressions, eligibility or qualification, now has come to the conclusion it is a qualification. Thereby, normally minorities cannot be heard to say, we don't want the qualifications prescribed. You can't say. If it is a qualification, it has to be accepted. Even though the 2 judges bench today come to the conclusion that this is only a qualification, therefore minorities are bound to follow that. Still, at the end, the bench says minorities for the time being need not follow TET. Why? Because, not that we want to say so, because in 2014 the 5 judges had said so. We being only 2, we are simply bound by that. Therefore, on the one hand, they say that because of our lesser strength, that is the 2 judges, we are bound by the 5 judges bench decision in Paramati, which declared the whole of the RT Act not applicable. Thereby, one limb of that RT Act, namely TET as such, is not applicable. By saying 2 or 3 things, one is they hold that TET is a qualification, and they also use a beautiful phrase, namely, TET is an educational essential, not an ideological imposition. That is how they term it. If it is an ideological imposition, the minorities can say, no, we will not follow. But if it is an educational essential, they can't say no. And this bench comes to the clear conclusion that TET is only an educational essential, not an ideological imposition. But still, again say, as long as Paramati judgment, which is delivered by 5 judges bench, is there, we can't deviate from that. We are bound by that. Thereby, minority institutions need not have the TET right now. They don't stop with that. They say further, because we come to the conclusion it is an educational essential and not an ideological imposition, we want the matter to be considered by a bench which is still larger than Paramati. Namely, larger in the sense above 5, obviously 7. Now the question arises whether the 2 judges bench, in the teeth of an existing 5 judges bench, can refer the matter to a still larger bench, because they are simply bound by that. There are 2 judges and they are bound by the 5 judges. Thereby, they adopt a practice, namely, they direct the registry of the Supreme Court to place this judgment before the Honorable Chief Justice of the Supreme Court, so as to decide the desirability of placing the matter before a still larger bench of 7 judges to decide what? 2 or 3 issues they have framed. One is, Paramati case does not deal with TET. It deals only with the 25% admission. Therefore, there must be a larger bench which is to decide whether the whole of the RT Act would apply to minority or would not apply to minority in the wake of this section 23, namely the TET application. And till such larger bench is constituted and that bench comes out with a decision whether TET would apply to minority or non-minority, as of now, TET is not applicable to minority because of Paramati, which is prevailing right now. Therefore, please remember, by this judgment on the 1st of September 2025, Supreme Court does not say that TET is not good for minorities. They say TET is good for minorities, good law for minorities, because it is an educational essential. But we are not able to say so because of Paramati's existence now, which is by 5 judges, and we wish that should be removed by a larger bench. This is the ultimate outcome, that is the sum and substance of the decision right now, so far as minorities are concerned. Now coming to section 12, which is the neighborhood admission. Though they say that Paramati's case, 5 judges very clearly dealt with that and said that any such compulsion to fill up 25% of seats by neighborhood children would be an affront, would be an encroachment on the fundamental right of the minorities. Even though that judgment is still there, and these 2 judges also agree, Supreme Court very categorically dealt with that provision of section 12 in Paramati. They now say we have our own suspicion over that judgment. we doubt that. We suspect that judgment. And now they say, what is wrong if the minority institutions also are asked to subserve the national interest by asking them to admit 25% in the neighborhood? And they say that any right of the minorities must also conjointly subserve national interest as well. Universal elementary education is a facet of the national interest. Therefore, minorities should also bear that burden. And a small leeway also they intend to say, namely, instead of asking the minority institutions to give 25% admission straight away to the neighborhood children, they can be requested to, by law, they can be asked to give preference even in that 25% to children belonging to the respective minority communities. Thereby, we don't say that 25% as such should go to non-minority outsiders, but the minority institutions can feel free to give preference to those children of their communities against these 25%. They also set out 1 or 2 reasons also for that. Why? Because, see, we now gain the status as minority educational institutions by way of certifications, either by the state government or by the National Commission for Educational Institutions, right? We take the certification. And after this declaration by the Supreme Court, or after the introduction of Article 21 capital A in the Constitution, the Supreme Court now goes on record saying that 85% of the minority status certification have been obtained by institutions only after 2006. So if there are 100 educational institutions as of now in the country, 85% of them got minority status certification only after the introduction of this Article 21 capital A. Thereby, these judges deduced that meaning. Because minorities are compelled, otherwise under this law, to admit 25%, they frantically go out and search for minority status to escape from that obligation of 25% admission. This is how the judges take in the judgment. They go on record also. Another one or two statistical figures. There is a commission, which many of you might know, National Commission for Protection of Child Rights 2021. In 2021, that commission made a survey, and the commission comes out with a report that all these minority institutions in the country overall, they give actually only 8.76% of students belonging to those minority groups. Only 8.76% as of 2021. So the remaining more than 93%, sorry, 92, 90, 91 point something percent, always minority institutions admit only non-minority candidates in their schools. So any admission above this 8.76% is always from the non-minority communities. And as such, this overwhelming, that is, they say again, 62.5% of the total students in minority schools belong to non-minority communities. The first is that socially and economically disadvantaged minorities, we admit only 8.76% from minority groups itself. Between minority and non-minority, non-minority students admitted in minority institutions constitute 62.5%, always above 50%. Therefore, this judge, by taking stock of all these statistical figures, these judges started developing an impression that this minority status certification or this claim of minority status is only to escape from the rigor of the law, not to serve the minority community. They hold the impression that if you are really interested in minority development, you would be admitting more minority students than non-minority students. But you are admitting only less than 35% minority students, and 62.5% students are from non-minority community. And again, among the minorities, socially and educationally and economically backward, you admit only 8.76%, not the whole minority candidates. These are the statistical figures which have prompted these two judges to take a slightly different view, a negative view about the minority institutions. And one or two lines I would feel that it would be appropriate to read. We are a bit distressed. The judges say we are a bit distressed to note from the materials placed on record, including the Child Protection Committee's study, the exclusion of the RTE Act has created a fertile ground for misuse. Since there has been a sharp rise in schools applying for minority status, the NCPR study finds that around 85% of minority institutions received their minority status post 2006, and there too many after the passage of the Right to Education Act. Therefore, they proceed as though all these institutions started claiming minority status only to escape from the law, not to serve the real interest of the minorities. If they are really interested in minorities' interest, they would have admitted more minority students instead of having 62% non-minority students. And they would have given more admission to the socially and educationally backward, much more than 8.76% what they have now. This is how they proceed. And the fundamental thing what is lacking in their appreciation is they must remember minority is a minority. Minority cannot become the majority to admit above 50%. If every time they are able to admit more than 50% students belonging to the same minority group, then they are no longer minorities. The very concept itself is minority. It can be from 1% or up to 50%. But most of the minorities are minuscule minorities. Take, for example, the Parsis and the Christians, which constitute almost 2 or 3% of the entire population of the country. How can you expect an institution run by this 2% population to admit more than 50% belonging to their community? If they are capable of mustering that much majority, they would cease to be minorities. That fundamental fallacy is prevailing throughout this judgment. And it is these statistical figures which led to the misconception. And this misconception resulted in the final verdict, saying that minorities cannot be allowed to escape from the law by way of this claim of status or obtaining these certifications. This is the end product. The end product is the saying that it is only an educational essential and not an ideological compulsion. Therefore, minorities must have this. The entire understanding itself is wrongly placed. When they say these minority institutions are trying to misuse the law, it is just the other way around. It is because of the fallacious understanding of the statistical figures. They must know fundamentally minorities are minorities. And there was a time in 2002 when the famous lawyer Fali Nariman, and we were all together because we also engaged him at that point of time. There was a question from some of the judges of the 11 judges bench. Some judges asked, then why that all these minority institutions, especially in the state of Kerala, most of the institutions are run by minority groups, and even the majority population is depending upon the minority educational institutions. Back came the reply from these lawyers that is it not a shame for the majority to say that still we are depending upon the minority educational institutions for the educational rights of the majority group? But that's the reality. At the same time, one example was quoted, a very extreme example, namely the Parsis, who constitute a very, very minuscule minority. And in an illustration was also shown. If they, located in Delhi, want to establish an institution, they can't muster even 5% of the students from the Parsi community, because it is a deteriorating community. It's a fast extinct nowadays. Very few families are there in Delhi. They want to exercise their fundamental right of establishment of an educational institution. If the state is going to say, unless you have 50% Parsi students there, we will not recognize you as a minority. If that be the parameter, Parsis, who are the minuscule minority, can never establish institutions at all. That is how the argument was advanced in the Supreme Court, and that suggestion from the bench fell flat. The point was, lesser the minority, greater the right. If I'm constituting 2%, my right shall be much more, because I'm a small, helpless 2%. And I need not depend upon the charity or the mercy of the majority. That is why Article 30, I have the fundamental right. That fundamental understanding of that constitutional phenomena is completely forgotten in this judgment. They proceed as though minorities are constituting the bulk, and they are taking the status as minority only for the purpose of escaping from the law. Otherwise, why they are admitting less students from their own community? They don't understand. Because they are less, they are minority. Because they are less, they are admitting much less than 50%. And incidentally, they subserve the educational interest of the other community simultaneously by giving more admissions to them also. That is the fundamental fallacy what I see in this judgment. But anyhow, coming to the ultimate result regarding minorities, 2 or 3 things. One is, because of Paramati's existence, as long as that judgment of 5 judges stand, minorities need not follow TET. By the same breath, these 2 judges say, but still we believe that this is an educational essentiality. Therefore, the Chief Justice may consider constituting a larger bench of 7 judges to consider whether TET is applicable for minorities or not. Until that happens, for the time being, minorities need not follow TET. This is the situation where we are put in now. As on today, minority institutions need not follow TET. Then coming to the implications if TET is made applicable, please remember it will have a threefold impact on institutions and the incumbents to be appointed. The first and foremost is when you appoint a teacher, the teacher must have already had TET qualification. That is at the entry level, at the time of appointment. Second is in-service candidates, the second factor. The teachers who are already appointed may be working for several years or even decades together. Should they have this TET eligibility pass? Supreme Court now says they should pass, and the time limits can be prescribed. Now the Supreme Court, these two judges in the 1st of September 2025 judgment say 5 years, 2 years now, 2 years is given for those existing teachers to pass or clear the TET examination. This is for people who are already appointed and working for several years or decades. Third is existing people when they are going for promotional positions, maybe for a secondary grade teacher becoming a BT assistant or so, if they are going to teach in this elementary level, whether they should again pass TET for that promotional position. These two judges say, yes, they must possess again TET for the promotional post also. Therefore, this application of TET would attack you on with a three-pronged attack. First is, at the initial appointment, you must have TET. Secondly, people who are already in service must pass a test within a period of 2 years from today. Third is that whenever they go for promotion, the promotional post also requires a TET. This is the implication if TET is made applicable. Now coming to the non-minorities, Supreme Court, these two judges say TET would apply to them because Paramati safeguards only the minority institutions. Thereby, RTE Act as well as the imposition of TET as an eligibility would continue to operate insofar as non-minority institutions are concerned. And the question may loom large now. People who are in the fag end of their career, maybe people who would have served 25 or 30 years, if they are asked to take out a written examination like this at the fag end of their career, how far would those people have the memory, have the ability to study and retain in their memory, and reproduce in the examination and pass this TET examination at this distance of time when they are about to retire? In the case of non-minorities, these two judges say they have given a leeway for them. If that person's leftover service is less than 5 years, 5 years or less, say for example, if 60 years is the age of retirement, if the person hasn't crossed 55, then TET is a must. Once you had crossed 55 on this date, that's the 1st of September, then you need not have the TET. You can safely retire. This is the position. Therefore, only the people who are at the fag end of their service, namely having 5 or less than 5 years of leftover service, they alone are saved from this rigor of having TET. Then you may ask me, what about the people at the age of 54? And should they pass the TET? Sure, they have to compulsorily pass the TET within 2 years. Though the 2 years may fall within the span of 5 years. Because you are now 54, you will have to pass the TET within 2 years. By the time when you clear the 2 years, you might have crossed that 55 years. But still you must have that. And what will be the consequence if you don't pass within 2 years? Even though you have already put in 30 or 35 years of service. Supreme Court says, retire them compulsorily. Make them walk out. They shall go out of service. If they are entitled for some other retirement benefits, give the retirement benefits to them, but not the entire retirement terminal benefits. They shall be compulsorily retired if they don't pass or clear TET within a period of 2 years. For all those people who don't have 5 years leftover service. Right? These are the broad outlines I would like to highlight in the wake of this judgment. Therefore, for non-minorities, the TET would apply at 3 stages. One is at the entry level. Second is even in-service candidates will have to take the TET unless they are at the fag end with less than 5 years of leftover service. Third is even when they aspire for promotional post, for the promotional post they will have to take again TET. Therefore, all the 3 would apply to non-minority institutions. If the larger bench which these 2 judges wish for, namely 7 judges bench, is going to be constituted, and suppose those 7 judges are going to tell that no, minorities cannot escape from this because this is, after all, as these people say, an educational essential. In that event, the same 3-pronged thing would apply equally to the minorities as well. So the relief that is granted to the minority is not permanent, only temporary, provisional. These are the broad outlines of the judgment of the 1st of September 2025. And I think that this would be sufficient for the time being. If you have any of you have got any questions to raise, please ask. And Father Kennedy must say how much time is left for this interaction, and how many of you could ask questions, please. Father Kennedy would.
Yes. Thank you, Isaac sir. Thank you, Isaac sir. So you have clarified both for minorities and for non-minorities. Both aspects are very clear from the Supreme Court judgment. Thank you.
Yeah.
Now the problem, I have 2 questions which can be clarified also. How is it that is it justifiable to put it retrospective? That is where the problem arises. See, retrospective implementation of the judgment, is it fair? What they've done is that one. And then it will also be the same for minorities. That is one thing. Second one, the Tamil Nadu government has promised that they're going for an appeal. Is it workable? Are they sincere? All that. No, I don't want to get into politics, but they have decided to go for an appeal on the judgment. Kindly enlighten us on these 2 aspects of retrospective implementation of the judgment and Tamil Nadu government's assurance that they are going for an appeal. What would happen? Thank you.
Yeah. Further, if you ask me my own personal opinion on prospectivity or retrospectivity, I would say that this concept of retrospectivity is something very, very ludicrous. Why? Because even the RTE Act, which propounded this theory of TET, itself says TET would come at the commencement of this law. This law dates back only to 2009. And according to law, the notification for TET came sometime in 2010. But now the Supreme Court says, forget about all those dates. Forget about the date of coming into force of the RTE Act 2009, or the notification for TET in 2010, or the subsequent modified notifications which took place later in point of time. Forget about all those things. If you are in service as on today, whatever be the date of your appointment, either even prior to the coming into force of the RTE Act, you will have to undergo this TET. That's what the Supreme Court says. Therefore, I am here just to explain to you what the Supreme Court says, and not my personal views what I carry. If you ask my opinion, this is nothing but a ridiculous. And when people come to be appointed, they know the qualification that is prescribed. They satisfy those qualifications. They take out those kinds of entrance or interview. They take appointments. And the person above 50 years now, maybe between 50 and 55, suddenly the law says that you have to undergo the test, and you also sit along with your students and take the examination in another hall with your students. That looks very ludicrous. And moreover, how can you expect the people at the age of 50 or so to memorize all these things and they take the examination for teaching for another 5 years? Whom? And what about their teachings so far? Or all these students whom they taught over 25, 30 years, all are disqualified because they were all taught by people who are unqualified? This is something, if you ask my personal views, my views would be very, very harsh. Just I am here to explain what the Supreme Court says now. Right now, therefore, your question is that whether it is retrospective, it is retrospective. But if you ask me whether it is good or bad, I would say with the all clarity that it is absolutely unwarranted. But anyhow, so minorities, we need not for the time being worry until the 7 judges come out with whatever they wish to say. But as for non-minorities, it's a real trouble. And what will happen? See, suppose, let us assume an extreme worst situation. None of our teachers in the government in the state of Tamil Nadu are going to pass TET in 2 years. What will happen? Will all the educational institutions be shut down?
Yeah.
When the Supreme Court fixes a time frame, it must do so after a great deal of reasoning. They must thrash out both the pros and cons, the possibilities and the impossibilities. Let us assume none of our teachers are going to pass in 2 years. What will happen? All our institutions will have to be shut down because all the teachers will have to be compulsorily retired. These are all things which are practically not possible. These are all good wishes, but practically not workable. And I'm told that the state of Kerala is moving a petition now to have a review of this judgment regarding the retrospectivity. Otherwise, it will lead to chaos. And if all the teachers' unions stand up and say, we are not going to take the examination, will the government be bold enough to say, all of you get out? We will shut down all our educational institutions. The law which intends to promote universalization of elementary education will destroy elementary education then. That would be the consequence, which will be very disastrous than promoting this universalization of education. Yeah. Anything else?
What about Tamil Nadu government's
I don't even for a moment suggest all your organizations must revolt and say that we will not take that. I don't say that. Just I am probing the possibilities. That is all. Yeah. Okay, Paul, tell me.
Yeah.
You can ask people to ask questions.
Yeah. My net connection is unstable, but yet I will organize. Those of you who want to raise questions, kindly, there is a symbol down. Those of you who want to ask questions, please raise your hand. I will give you opportunity to ask. Or if there is a symbol, the symbol raising hand symbol, you can also that react. React. You can also put that symbol. I will give you a chance. Anybody who wants to ask some questions, please. We will take 10 more minutes. We shall take 10 more minutes. Those of you who are watching, 80 people are watching in YouTube. Please type your questions in the chat box in the YouTube. Yeah. Anybody else? Anybody wants to clarify? I think things are very clear, but yeah. Reena Mary Shirley, please. Yeah, Reena Mary Shirley, unmute your mic and ask your question. Yeah, be short, brief. Thank you.
Sir, 2010 appointment, sir. I am worked for 14 years. I'm worked as a BT assistant. Last year, I am promoted as a PG, sir. So they are not recognizing my post, sir. Still, I'm not getting 20 months. I'm not getting the salary, sir. What to do, sir?
Isaac sir, the question is very, I think many of us have this question. From BT to PG promotion, now they are not giving approval, showing the TET. So what is that? What is the standing? And I also personally, as a Jesuit, want to ask, some of the PG Jesuits are going to be promoted as headmasters. And there will the TET interfere? Both these please address. Please address. Yeah. Over to Isaac sir.
Is the question from a sister or a layperson in a minority institution?
Reena, are you a sister or a layperson? Reena?
Layperson, sir. Layperson.
Yeah. Thank you. Thank you.
Working in a minority institution?
Yeah, sir. Working in a minority, sir.
As I told you right now, as of now, TET is not applicable to the whole of the minority institutions. Even in case of non-minority, if your promotion is to the post of higher secondary, maybe these are postgraduate assistant or headmaster in a higher secondary school, this TET won't apply. Why? Because TET is a byproduct of the RTA Act. That law governs only elementary education, namely children studying or children with the age group of 6 to 14, maybe the primary school, middle school, and high school, not at all to higher secondary school. Therefore, any promotion to the post of PG assistant or headmaster in a higher secondary school need not have this TET at all. And because you are in a minority, for the whole of the minority, it is not applicable as of now. Therefore, you can straight away ask for approval and salary. Okay?
But
Okay,
they are
madam?
not, sir.
Yeah.
They are not passing my SR and my certificates from DO's office, sir. What can I do for that purpose, sir?
That is not the problem of the law. It is the problem of your DO or CO. Therefore, if they don't do that, you will have to agitate. You send a reminder asking them to do it. If they don't do it, you will have to come to the court only.
Okay. Thank you, Isaac sir. Thank you. The clarity is there. Now there are 3 people who have raised their hands. Kindly, my request to Isaac sir is kindly listen to all the 3 questions and try to answer them. Mr. Ganesh, Father Francis Xavier, Father Cyril. First chance to Mr. Ganesh. Ganesh, raise your question. Sir will answer all the questions together. Mr. Ganesh, unmute your mic and ask. Ganesh, unmute and ask. Okay, I think Ganesh is trying to unmute. Okay, Father Francis Xavier, then Father Cyril. Father Francis FX, please unmute and ask. Only audio. Ask. Yeah, we will wait for Francis to unmute. Father Cyril, carry on. Father Cyril, carry on.
So I am.
Cyril, yeah.
I am speaking from Delhi. See not the question. Already in the northern states, they have closed down about 1 lakh schools, primary and high schools. So it is a big disaster for the children. So it's a violation of right to education. So I think behind this judgment, there is a motivation. They want to reduce the number of teachers, the entire country, because of economic burden. I think this judgment has got a lot of inner motivation. This is my observation. I think the entire country, the teachers have to come to the street and protest. This is ridiculous, and the education of the children will be getting affected. Another thing, basically, it's a violation of right to education. So this is my comment and observation. Thank you.
Thank you, Cyril, for the observation. I give the chance to Mr. Ganesh. Ganesh, unmute your mic and ask the question. Mr. Ganesh, chance is given to you. Please unmute and ask. Mr. Ganesh. Okay. Father Francis, are you ready? Ganesh, unmute the mic and ask the question. Mr. Ganesh, chance is given to you.
Sir, good evening, sir. Good evening, sir.
Yeah.
நீங்க
Yeah,
ஒரு
yeah.
unmute
Please,
sir.
please wait, please. But I will coordinate. Mr. Ganesh ask. Yeah,
யாரு on பண்ண சொல்லுவாரு. இங்க
Good
வா.
evening, sir.
yeah.
நிறைய கைது செஞ்சிருக்காங்க பாருங்க. ஒருத்தரை பிடிக்கிறது.
Please ask.
Sir, good evening, sir. I'm talking from Tiruvarur district, sir. I'm a government school teacher. I was appointed in 2005, sir. Is it mandatory for me to attend the TET examination? Whether I have to pass the TET examination? Is it compulsory, sir? Because I was appointed through TRB, Teachers Recruitment Board. I have been working for the past 19 years, sir. Is it mandatory for me also, sir? That's the thing I want to ask. I need clarification, sir. Thank you, sir.
How
Mr.
many years
Ganesh,
you have
Mr.
got
Ganesh,
to
hold
retire?
on. Mr. Ganesh, hold on. Isaac sir will answer all the questions together. This is one Vivo V2347. Please unmute and ask. Yeah. Please unmute and ask. Isaac sir will answer together. Vivo, I don't know your name. Sister Vasanthi, unmute and ask. Sister Vasanthi, ICM, unmute and ask. Unmute and ask. Sister Vasanthi, unmute and ask.
Father, just call out the name. I'll unmute them
Hello.
because. Yeah.
Sister Vasanthi, yes.
Hello.
Yes.
Good evening, sir.
Ah.
Good evening. 2016 and 17, 18 like that. 4 teachers are appointed in our school, minority school. But in spite of, we have challenged that in the court, we have got good judgment. But still, the DOCO, they have not approved those posts without it. But we have gone through the case and got judgment. So
Thank
now
you.
you say
Yeah.
minority schools don't need TET, no, but still we are struggling. Last 8 years, the teachers are struggling. In
Thank you.
Ignatius.
Thank you, Sister
Thank
Vasanthi. Your question will be answered. Tamilarisi ma'am, please unmute and ask. Tamilarisi ma'am. Sir will answer all the questions together because lack of time. Tamilarisi
Good
ma'am.
evening, sir.
Yeah.
Okay, sir. Good evening, sir. Sir, if a teacher takes medical leave, the institution appoint another teacher. Is this teacher must pass the TET exam? Thank you.
Thank you for the question. Then Samsung SMG. Who is that? I don't know. Unmute and ask. Samsung SMG.
Yeah,
Yeah.
good evening,
Yeah.
sir. Sir, actually, I am asking for my mother. Actually, she working as a headmaster from 2019, sir. Her retirement period is 31/5/2030. So, if she need to write the TET exam, sir, if any recruitment for that, sir?
Okay. Kindly mention whether minority, non-minority. Yeah? Both are important.
Minority, sir. Minority.
Okay. Thank you.
Actually,
Thank you. All the questions will be answered together. Vivo 2347. Vivo 2347. Please. Yeah.
சார் வணக்கம் சார்.
Ah.
சார் முதல்ல ஐசக் சாருக்கு என்னுடைய வணக்கத்தை தெரிவிச்சுக்கிறேன் சார்.
Please go to the question.
சார் இப்போ வந்து 2 நீதிபதிகள் கொண்ட பெஞ்ச் வந்து பரமத்தி ஜட்ஜ்மெண்ட்டை மாத்திரக்கு உண்டான சான்சஸ் இருக்கா சார்? இது ஒரு கொஸ்டின். இன்னொன்று சார், இப்போ ரிவ்யூல வந்து இப்போ தமிழ்நாடு கவர்மெண்ட் ரிவ்யூ போயிருக்காங்க, அதுல வந்து தீர்ப்பு அந்த ரிவ்யூ வந்து இப்போ கொடுத்த தீர்ப்பை மாத்திரக்கு உண்டான வாய்ப்பு இருக்கா சார்?
Thank you. Paul is the last person, then Isaac sir will answer. Paul, there is one Paul. Yeah. Ask your question. Isaac sir will answer together. Yes.
Sir, if as of now, if somebody has passed the TET exam and got appointment, then if he's getting promoted, should he need to appear for the TET once more?
Thank you. Amalarajan, TN STF, please ask your question. Amalarajan, last. Yeah. Amalarajan.
குட் ஈவினிங் ஃபாதர்.
Yeah.
அரசினுடைய கொள்கை முடிவுகள் வந்து இந்த முடிவுகளை ஜட்ஜ்மெண்ட்டை மாத்துறதுக்கு எதுவும் வாய்ப்பு இருக்கா அப்படிங்கறதான்.
Valid question. Yeah. Isaac sir, if there's a policy decision of the government, will the judgment hold good? So kindly take all the questions together. Please answer. Isaac sir, please answer. 5-6 questions are there. Please over to Mr. Isaac. Yeah.
Father Cyril's question that lots of schools are being closed, whether this judgment is motivated or so, and there can be a protest also. The judiciary is not a democratic institution where the popular protest may not work, because courts are concerned only with interpretation of law and the constitution. And it is always good to argue before the court instead of protesting before the court. And Mr. Ganesh appointment through TRB in government school in 2005. See, but even though the appointment is in 2005, he has to take the TET examination. Though the appointment is dating back to 2005, and though it was through Teachers Recruitment Board, still, because this is a qualification now adduced, you will have to take the TET examination and clear it. And Sister Vasanti's question that she has got a judgment, but yet not approved. If the judgment is in her favor, certainly it will result in approving the appointment of those people who are appointed now. And she has to take further steps to get the judgment implemented. Shanti asked a question whether in the medical leave of the regular staff, suppose somebody is appointed as a substitute teacher, whether TET is needed for substitute teachers also. My answer would be substitute teacher also will fall within the definition of teacher.
Okay.
As long as he or she is a teacher, TET is a must.
Good.
Then someone asked that 31/5/2030 is the retirement of the mother who is working in a minority institution. Because it is a minority institution, the TET is not needed. And moreover, 2030 obviously is, yes, it is less than 5 years left over service. Therefore, even if she is working in a non-minority institution, TET is not needed because of the present judgment, because it is falling short of 5 years left over service. Then, and someone asked whether the present two judges can overcome 5 judges. That is why I cautiously told you, these 2 judges, though they make all observations against the 5 judges' judgment, but at the end, they don't give the judgment against the 5 judges. They say, though we are carrying a different view, because the 5 judges have said so, we are obliging to them until still larger bench of 7 judges decide otherwise. So far, so good, as long as the 5 judges' judgment stands. That is how the 2 judges say. They don't overcome 5 judges. Then Mr. Paul asked, appointed without a TET, and do they need to pass again for promotion? Yes, for promotion also TET is required if it is a non-minority institution. Then the government policy, Amalanathan asked whether the policy as such can be changed by the government itself. So now this RTA Act is a central government law, and central government can deliberate on that by passing a law. They can change the policy, but I don't think that they would do that, especially in this political scenario and the present political dispensation in power. I don't think it would ever happen. I think that these are all the questions. Father Kennedy?
Yeah. You answered all the questions. You have answered very well, very well. Yeah. The last chance for just 5 more minutes, friends. Kokili Ghosh. Kakoli Ghosh. Yeah.
Kakoli Ghosh.
Yeah. Kakoli Ghosh, you want to have a question?
Yes, sir. Good evening to all of you.
Yeah.
Myself, Kakoli Ghosh from Carmel Convent Secondary School, Raigad, Chhattisgarh. We are basically from a very, you can say, very less populated area, and it's not very posh area in our state. So I wanted to just quote one thing and ask one question from Father. According to the Supreme Court RTI in 2009, all the students up to 14 years should have a compulsory education. This is according to the RTI. My question is, if according to one sir who told that near about 1 lakh schools have been shut down, and he feels that it's a motivational move in respect the teacher should have a TET exam compulsory in the school. And if the teacher doesn't have, the school should shut down. Is it really worthwhile? like RTI
Yeah,
says
thank you.
it's a
Thank you.
compulsory move, right?
Thank you.
Yeah.
Thank you, Ghosh Mom. Thank you. Thank you. Sister Zina FMM, please unmute and ask. Sister Zina FMM, unmute and ask. Yeah, ask. Yeah. Sister Zina, George, Sister Zina. Okay, I think just a minute, sir. I will just see whether anybody else. I'm just going over other. Okay. Okay. I said, sir, you can respond to this question. That Ghosh man's question.
And her question seems to be whether this law itself is politically motivated, because resulting in shutting down of schools. I don't say any, because this law was passed sometime in 2009, when the previous party in power, you know that it was by Congress party in implementation of this Article 21 capital A. The basic core idea was universalization of elementary education provided by well-qualified teachers, because you know that the pass is automatic. You can't detain students up to 14 years. When pass is guaranteed, the students must get promoted from standards low to standards high. They thought that quality education would be possible only by with the help of qualified teachers, and probably they would have found that the qualifications for the elementary teachers, maybe Tamil Nadu and the southern states are always an exception. In northern states, the quality was so below. Thereby, they would have applied this system of TET. It was in 2009, actually, and it was notified in 2010. Therefore, I don't find any apparent political motive on all these. But the way in which it is implemented very drastically and in a confused way, actually, they are only leading to these kinds of problems nowadays. But as of now, you can be rest assured, till the 7 judges bench decide, the minorities are absolutely saved from the TET. And at the same time, the non-minorities, they were never saved right from 2010. The same position continues. And this
Isaac, sir, mic is unmute. Please unmute. Unmute your, yes.
Are able to hear now?
Yeah.
And this last part of the judgment, saying that now we are giving you 2 years, whatever be your past service, maybe 25 years or 30 years, you will have to take that examination within a period of 2 years is too harsh, in my opinion. And that will lead to still more confused situation, because I hope that teachers beyond 50 years would be able to clear these written examination at that fag end. That would result in greater confusion. That's what I believe. Right?
Thank you. Thank you, Isaac, sir.
Political motivation apparent.
Okay. Thank you, Isaac, sir. Isaac, sir, you have not only clarified our doubts and confusions, also gave us your opinions and insights in the whole matter of the judgment. We are very much grateful to you. We are indebted to you for all this clarity, for your valuable time and your commitment, above all, your commitment to the cause of the minorities. Hats off to you. We always welcome, we always support you, all that. Okay, thank you, Isaac, sir, for everything that you have made this webinar very interesting, interactive. I also like to thank Father Sandanam for jointly hosting this webinar, Father Simon for the initial prayer, and Sister Amala for the ambience created through her welcome address, and Mr. George from St.Mary's Madurai for doing the taking care of the technical aspect, and finally to St. Joseph's College, Trichy, for giving us the Zoom link, everything. So, participants, the webinar has been a success only because of your active interaction, active listening, active participation. Thanks a lot. Once again, may God bless all of us. Let us go peacefully to sleep together, to sleep well today.
One
Confusions
question,
are clarified. So, thank you. If there is a need, we will once again organize a webinar later. Thanks a lot. May God bless all of us. Father Sandanam, any last word you have? Father Sandanam?
Father, I have one
Sandanam. So I think my mic was muted. So I like to conclude. Yes, Sandanam.
Kennedy, Sister Vasanthi is repeatedly requesting us. Maybe we can give a chance to
No, that's
her.
okay. There are several who have raised hands. Sandanam, not only Sister Vasanthi, we can clarify with this, Dr. Mr. Isaac. So I
okay,
think
good.
Yeah,
Good.
I think my mic was muted. Did you hear my thanks, Sandanam?
Yes, we heard your
thank you. So once again, participants, thanks a lot. Thanks to everyone. Bye. Have a pleasant night. Bye.
Thank you.
Thank you, sir. Thank you.
Yeah. Thank you, sir.
Isaac, sir. Thank you.
Thank you so much, fathers. Thank you so much.